It's great to have you at the law school, Adam. Let's dive right in. So, two of the professions that are most threatened by the rise of AI are journalism and the law. You have done both. I would encourage you not to take up computer programming. So, can you tell us about your move from law to journalism?
So I always wanted to be a journalist. I was on the school paper at Yale. I was, after college, a copy boy at the New York Times, which is as menial a job as the title makes it sound. And I was hoping someone would notice me and turn me into a New York Times journalist. And aside from writing a magazine article about playing air guitar, uh, I got very little traction. Although one thing they did have me do is help cover a big libel trial that General William Westmoreland had brought against CBS. Back in those days, the networks didn't settle libel suits. And that gave me the idea that maybe I wanted to be a libel lawyer. And I went off to law school, also at Yale, and thought still that somehow I might work my way back into journalism. But I worked at a Wall Street law firm for 4 years. Then I went in-house to the New York Times Company's corporate legal department, figuring if I can't be a journalist, at least I could be near journalists, could try to help them. I did that for 10 years, and then wrote some freelance stuff, and a little bit for the Times itself, which was probably a weird conflict of interest or something. And the editor at the time had this crazy idea that he was going to get the guy from legal to come down to the newsroom and be a reporter. It was an insane idea. And I show up, I start my journalism career on the national desk of the New York Times without the most rudimentary journalistic training. And it was 6 months of pure terror. I didn't have any sources. I didn't really know how to write an article. I was pretty good at reading legal materials, but that's only one part of the job. But I gradually got the hang of it. Did that in New York for 5 or 6 years. It was a great job. I tried to find stories that nobody else was writing about. I roamed the country. I wrote a series of articles about how the American legal system is distinctive, different from other legal systems. And then, to my great dismay, the legendary Supreme Court reporter Linda Greenhouse goes and retires. And I had this suspicion they'd asked me to go cover the Supreme Court, which I didn't want to do at all. I didn't want to follow Linda. I didn't want to move to Washington. I didn't want 9 people in robes picking my stories for me. But I couldn't figure out how to turn it down. It's a prestigious job. And I did that for 17 years. And it was, as Robert Bork said correctly, an intellectual feast. It's really fascinating stuff. But also wearing and a grind, and you have to write a lot of stuff on deadline, and you're not doing what journalism really prizes, which is the distinctive, the scoop. You're writing the same story as 20 other very good reporters on the Supreme Court beat, right? And with the rise of the internet and the rise of the emergency docket, you're writing very fast. And that's frustrating, so that when Linda covered the court, she would not write for the web. She would write for the next day's paper. She would get a decision at 10 o'clock in the morning, read it start to finish, consult with experts, have lunch, for all I know, take a nap. And at about 6 o'clock at night, she'd file her story. I was filing stories like 5 minutes after the decision landed. I basically just got the outcome right, and luckily, it never wrong. But I'd slap a lead onto what in the newspaper jargon we call B matters, sort of uncontroversial background stuff, and that would go out, and there's a news alert, and then through the day I'd make the story better and try to give a sense of context and consequences and doctrine. And by the end of the day, I'd write a Linda quality story that no one will read, because there's a complete inverse relationship between size of readership on the initial story and quality of analysis. So that was frustrating. And then, the emergency docket is only worse because you don't get any heads up about when the decision is coming. And maybe we'll talk about this. There's often no reasoning, so you're trying to intuit what the court had just done.
We'll definitely talk about the emergency docket. But unlike the applications for fast action by the court, we've got time.
Good.
We can get to it. So over that stretch of time, those 17 years covering the Supreme Court, what changed about the court as an institution for the better, and what changed for the worse?
The court became more transparent in two ways. One small, but actually fairly important for us reporters, and then one large and good for the nation. The small one was early on. We asked the Chief Justice, well, a couple things. There is some interaction between the press corps and the court about how coverage works. It used to be that the orders list, typically on Monday mornings, would come down at 10 o'clock in the morning as the arguments were starting, or sometimes the decision announcement and then the argument, which made it very hard to do two things: to cover the cert grants that were often on those orders at 10 o'clock and also be in the courtroom to cover the argument. And we asked the Chief Justice, well, what if you did it at 9:30? And he said, well, aside from the press asking for it, I can't think of a reason not to do it.
What year would that have been?
That was 2010.
Okay.
And similarly, it used to be that the transcript would not be available for days. And it's hard to cover an argument. And until the pandemic, the only way you could go to know what was happening in a Supreme Court argument is to go there. So, and having a prompt, and you can take the best notes you like, but it's hard to get an extended quote. So getting a prompt transcript was important. And then the larger change came with the pandemic, when something revolutionary happened that would not have happened but for the pandemic, which was live audio. And live audio is great for the nation. It allows everyone to listen in on the argument. Having the audio gets you like 90% of the available information. If you recognize the voices and you have some background in the case, that's really great. That was sort of bad for journalism, or bad for Liptak. Because now I didn't have exclusive access to the argument. Only people in the courtroom used to know what was going on in the argument. And when you were in the courtroom and only you knew what was you and the couple hundred people in the press corps knew what was going on, you could walk down to the press room and have a chance to consult with your colleagues. It was press colleagues, it was very collegial, and you would write fairly promptly, and no one could really catch you because you had this exclusive look at what the court was doing. With live audio, everyone is in on the game, and you have to write fast. In fact, you kind of have to start writing during the argument. It meant I no longer went to the courtroom for the big arguments because you couldn't be isolated for what, and here's another difference, the arguments got much longer. I'll talk about that in a second. You had to be prepared to write right away or live blog it, and it didn't result in a good, coherent story. This speed was a negative. Then the other change mechanically in oral arguments is that they used to be strictly an hour. Very occasionally, the court would add a little extra time, but basically Chief Justice Rehnquist would interrupt people in the middle of a syllable when the hour was up. And Chief Justice Roberts was also pretty strict on time. During the pandemic, the court, just to solve the problem of how this is going to work when they were hearing arguments by telephone, gave up the free-for-all questioning, which is a good, dynamic, valuable way for the court to act, and went to the much less satisfactory seriatim questions, where one justice at a time would ask a series of questions in order of seniority. There'd be very little interaction among the justices, and they made do with this over the pandemic. It had the incidental benefit of Clarence Thomas started to talk. And then when the pandemic was over and they decided, they were debating how to go back, what form of questioning to ask when they're back on the bench, they came up with a hybrid model, which has the dynamic questioning, the free-for-all questioning for the first hour, and then tacked onto that the one-by-one questioning, and it's not great, and it goes on forever. Arguments will go on for two plus hours.
My third grader recently said, I have a question. It's actually more of a comment. Yeah. And there's a lot of that in the oral arguments. So I share the sense that they go on too long, they're flabby, but I don't know if it actually has much of an effect one way or another on the justices' collegiality, on the opinions they produce. I mean, it taxes the patience of the listener, but does it actually, like, is there a bad effect for the court that the oral argument's too long?
No, and justices have said to me, like, what else am I going to do? I'm sit in my office? I mean, this is good. I think I do have the sense sometimes that they're less engaged in the first part of the argument, and they're saving some of their best questions for the seriatim questions, partly because, Kagan's happy to go after Alito, and knowing that he can't respond, for instance.
Now, all of the changes in the Supreme Court that you mentioned are at the institutional level, sort of the mechanics of how the court works, and not the people on the court.
Right.
So well, any departures that you, like, which departure do you think has been most pivotal or influential for the court since you started covering?
The answer to that is obvious. When Kennedy left, the court really changed. Kennedy was so much the decisive figure on the court that it seemed like advocates were only arguing to him. And the other justices would routinely say, well, as Justice Kennedy was saying, and that's such a good point. And I think what he meant was, I mean, Kennedy's influence on the court was enormous. He probably has very little lasting impact. I mean, he wasn't the author of great doctrinal insights, but he was the decisive vote. So when Kennedy leaves, you have Kavanaugh replace him, who has significantly more conservative, but is also initially, along with the chief, sort of in the middle, and you have a court that's not all that different. And then the second major change is Barrett for Ginsburg. And now that you have a 6-3 Republican appointee majority, the dynamics at the court are that it's moving consistently to the right, And the only question is, how much do the three justices in the middle, the Chief, Barrett, and Kavanaugh, sort of tap the brakes? And it's less satisfying because it's more predictable. So whether you like the outcomes or not, to cover the Kennedy court, you had the sense that in many situations, the outcome was not pre-cooked. There was some chance of something interesting happening. And these days, there's much less of that.
And the court's taking many fewer cases. So does that like reduce the sort of randomizing element? Like if you take more cases, then maybe you'll mix it up more? Or does taking fewer cases mean they can give them all more attention on the regular docket? Like, is that does that connect in with the unpredictableness of the Kennedy court?
I think so. I mean, if the court took, as it once did, 125, 150 cases, they'd have to do more law. They'd have to, I mean, it's actually astounding that the court on the merits docket is like really not a hardworking court at all. 60 decisions means that each justice writes 7 majority opinions a year, aided by 4 brainiac law clerks. I mean, that's not a heavy lift. Now, sure, there's a cert docket. There's these days the emergency docket. But there's something awry here.
So during the time the court's changed, the press has changed. So do you feel that the coverage of the Supreme Court by reporters is substantially different now than it was when you started?
I think the Supreme Court press corps that has hard passes, goes to the court, was and is very good. And
who's your favorite reporter, not named Liptak?
That would get me in more trouble than maybe.
I tried.
The quality of the standard issue press corps is very good and engages the court on its own terms and tries to translate for the public on deadline difficult legal materials and does a good job and is not influenced by politics. But that's a small slice of Supreme Court coverage. There's a lot of kind of opinion journalism, advocacy journalism on both sides that can be very tendentious. There's reporting that's not reporting on the public acts of the court, which is a mixed quality. Well, maybe I've said what and then there's kind of a rise of academic-y coverage of the court, strict scrutiny, amicus, divided argument.
Good plug. Along with the more academic coverage, there's also lots of scholarship that the court may or may not be reading. What's your sense of what effect at all legal scholarship has on the Supreme Court, and particularly with the court's more conservative and originalist turn? What effect, if any, do you think originalist scholarship has at the court?
I think the court is very attracted to originalism. I'm not sure that it's attracted to it as actually supplying the rule of decision, but as a kind of rhetoric. It likes the idea that there may be a way of thinking about the Constitution that supplies answers that are objective in some sense. But I think it's quite early days at the court. They really don't know what they're doing yet with originalism. Bruin it seems like a mess to me. And
it apparently seemed like a mess to plenty of the justices too.
Yeah.
Hence the cleanup on aisle 7 in Rahimi.
But there's a lot of citation of law review articles, sophisticated law review articles. I mean, you probably have a better view of this than I do, but I think it's more decorative than actually helping frame the issues. There's this Robert Sack on the Second Circuit once talked about law review articles, and he said that they're like when a drunk leans on a lamppost. It's more for support than illumination.
We have a lot of lamppost architects in the room. I hope you enjoy your contribution. So, Adam, you've had a big story this week, and it's I'm sure lots of people have read the article, listened to the Daily, read your follow-up article on the docket. Let's, as an entry point into the question of the memos, the Clean Power Plant memos in 2016 from the Supreme Court's deliberation about the stay. In your as a way in, I want to pick up on something from your docket piece where you canvass some of the response, critics, different takes. By the way, I thought that was fantastic to do that, to sort of recognize what the different perspectives had been and engage with them substantively. So in that piece, you have a quote from Bickel about the tension between the confidentiality that the court needs to do its work and a free press on the other side, and its reporting on what the court does. So how do you think about that tension? How do you think about that tension for you, for the court, for just generally? How do you approach it?
Right. So Bickel says, Alexander Bickel, the great constitutional scholar, died young at Yale Law School, who represented the Times in the Pentagon Papers case, said it's a disorderly situation. Sure, and these are incommensurate values. It's very hard to choose between the government, which does need to maintain its secrets to do its job, and the press, whose job it is to illuminate the government, and including by publishing newsworthy, accurate materials about what goes on in important government decision making. And it's each side has a role to play. My role is to bring newsworthy information to light. And Erwin Chemerinsky once said something which seemed correct to me. He said, knowledge is better than ignorance. And I think the reaction to the papers we published, and I think, so this goes to the point also, you could write one kind of article that characterizes what went on at the court, and those kinds of articles are, not uncommon. After the Affordable Care Act decision in 2012, it was promptly revealed that the chief had switched his vote, and that's important. That's big news, but it seems different in kind if you can supply the reader with the actual documents and let the readers make their own assessment of what had gone on there. And so even uh, that that kind of factual predicate both seems to drive people crazy, but also gives rise to a really valuable and interesting discussion. So there's all kinds of reactions to the piece, but I think it's indisputable that a lot of it is engaged with the serious questions the article raises about what went on over 5 days at what really can't be denied was an inflection point in the court's approach to emergency applications.
So I want to get to the merits of that in a moment, but first, I didn't want to read them, and they were absolutely fascinating and riveting. So I think you're right that the documents are different than the description of the documents. But I want to go back to your answer on the tension just a moment, because the way I understand what you're saying, Adam, is a kind of role morality, which we as lawyers are very familiar with, like the zealous advocacy of the two sides, and the judge sorts it out. Now, I have two hesitations about that, though. So one is it sets up a role morality of the press on one side and the courts on the other, and that makes me worry that it's just going to be like conflict. But the other thing is we often have a role morality that doesn't necessarily exist as, like, in the mathematical sense, a ray that just keeps going in one direction. It's got its own, like, internal sense of striking a balance between the two sides. So you think of like a prosecutor's discretion not to prosecute.
Yes.
So we don't say the prosecutor's job is to prosecute, so prosecute everything. So do you feel like you, in your role morality on like shedding light, also have to incorporate in some sense the tension? Like, what is this going to do to the confidentiality of the processes at the court and its internal working? Or is that like not my business?
So the answer to the narrow question is that's not my problem. But there's a broader question, I think, suggested by the narrow one, which is I don't think we willy-nilly publish every secret we find. I mean, we do make a mature judgment about what is newsworthy. And I mean, we may well know many things about the court that don't warrant a story because it's too trivial, and maybe even somewhere in that balance is I withdraw that. No, I mean, we're in the business of finding stuff out, evaluating it, and if it seems to us to be useful to citizens in a democracy to know something about their government, we publish it.
So the response I had on the merits of the memos are that it does seem like you characterized it as an inflection point. And that seems exactly right by the way the justices are arguing. None of them are saying, well, remember that case 3 years ago where we decided what our principles were going to be for this. They're applying some existing law, cases like Nkin v. Holder and stays and things like that. So it's not like they're writing on a blank slate, but they do feel like they're wrestling on the cusp of something that was about to become one of the dominant legal trends of the last decade.
Well, you have the chief saying it's novel. You have Kagan saying it's unprecedented. You have Sotomayor saying it's unprecedented. So it's not like a follow-on to Little Sisters. It's its own thing.
Mm-hmm. Mm-hmm. I think that's right. Now, there have been a variety of takes on how good the arguments are in the memos. My own view is that I found really good arguments in each one of the memos from the different justices, that they were wrestling with the right issues in a way that They're setting basically the contours of the debate for what would follow. So just to pick out one example, the last paragraph of the Alito memo had what seemed to me a really good argument and a bad argument that were put together. So the really good argument was that the court should think about whether to issue a stay in terms of whether it is necessary to preserve meaningful judicial review. And for all kinds of interim measures, preliminary injunctions, stays, other things, I think, some consideration of the merits is relevant, but that should be the critical consideration, is it needed to preserve the court's ability to give an effective remedy to effectively decide the case. Now, so that seemed like a really good point. And the point that was paired with it is, we have to do this or else we won't be legitimate. But judicial legitimacy, I would say, does not depend on solving all the problems. You answer the cases that come to you, and as long as you answer those responsibly, that's your job. It's not like the comic about somebody being wrong on the internet. So you have to, like, the judge's job is to go stop it. So I don't think judicial legitimacy turns on that, but I think that was the right framing for how to think about it.
Right. Now, what do you think about, in retrospect, whether they were right that they needed to act?
So in retrospect, ex post, my understanding from colleagues who know much more about environmental regulation than I do is that they didn't need to act because the price of renewable energy fell very rapidly and basically meant the reg didn't do anything. Hindsight is a boon. Yes. So one more question, if I can ask you before we turn to questions from the audience. One of the things that I find most skepticism inducing about the shadow docket or emergency docket or interim docket, or as Professor Resnick termed it in one of our sessions earlier today, the dash docket. So one of the things I find most skepticism inducing about it is the epistemic effect, that it means you take what your initial impression is and you just sort of lock in on it. And the deliberative process, the fact-finding process, is supposed to be able to move the judge, who starts in one place to another place, and that does happen in our legal system. But there's a kind of like follow the first answer you put on the Scantron. I guess I'm dating myself. Some people in the room might not know what that is, but so that kind of tendency is not good. And so I can imagine, and so the court does its best work when it works slower. I think this critique of the interim docket is exactly right. But I can imagine a New York Times reporter who gets a request for a story the next day saying to the editor, I do my best work with months of deliberation. I need more time. I'll do it better. And the editor says, that's great, 5 o'clock tomorrow. So should we call this not the shadow docket, not the emergency docket, not the interim docket, but the New York Times deadline docket?
Well, listen, if it's an authentic deadline, if someone's about to be executed, you got to work fast. If it's something that is going to be rolled out in a sequence that ends in the year 2030, you maybe have more than 5 days to deal with it. And the court has set cases down for argument. This case is big enough that or even granting cert before judgment might have been appropriate. It doesn't seem to me like a 5 o'clock tonight deadline.
Mm-hmm. Mm-hmm. Ripeness is all, to quote King Lear. Questions from the audience? So the question is, one way Adam's coverage of the Supreme Court is distinctive is he takes seriously social science research on the court, and that was less characteristic of his predecessor at the Times. How did you come to do to
so
that position?
I try to look for, what's the word? empirical, objective things to say about the court. And early on, when I think I started covering the court in in 2008, and early on, I think Souter had dropped a footnote about, well, it doesn't matter what it was about, but it caused me to call a political scientist named Lee Epstein, and she had numbers that illuminated the question Souter had raised, and I found that intriguing, and it caused me to collaborate with Lee over the years quite a lot. In fact, we taught a class here in Chicago for a short course for 7 or 8 years, and also opened a window into other sort of data-based ways of looking at the court. It's just, I mean, it's so easy to think of the court as either political or engaged in only doctrinal activities, and the empirical stuff gives you a clear picture of the court, and it seems to I mean it confirms intuitions. The data and what you see with your own eyes support each other, and that seems valuable to me.
Mm-hmm. Mm-hmm. If I can repeat it, the justice book writing industrial complex. What are your views?
It's largely because the justices can't make money in other ways, so they can teach and make $20,000 or $30,000, but aside from books, there's no way for them to supplement their income. I think on the whole, it's not healthy. I think the celebrity culture surrounding the justices is bad. I don't think the justices, and they tend to promote their books on their side of the aisle. There's a place in the world for the memoir. The Thomas book is good. The Sotomayor book is good. So I think the memoir part is harmless. The books on how to think about the court, the Bray Barrett books, I don't hold them in particularly high regard. I think the justices should work on their day jobs.
Well, one possibility is not many people listen to academics, but justices could do what academics do and try co-authoring.
Well, I mean, Gorsuch is writing books with a co-author, and I suspect she does much of the work.
I mean, co-authoring across the aisle, as it were, on the court. So you could get justices typically in the majority and justices typically in the dissent writing together. The adversarial collaboration that's starting to take off in social science. Yeah. Next question. So the question is about Alito retirement rumors and whether Adam has inside information that he is willing to share.
There were reports by Fox News and Janet Crawford, both of which have good access to Alito, and it seems like he has signaled that he's not going.
So the question is about with the length of oral argument changing, one thing that's changed is the justices are not interrupting counsel as frequently, especially during opening statements. Do you have any reactions to that development?
So that's a formal rule now, that you get 2 minutes of uninterrupted time. As far as interruptions during the argument proper, I think those are still common. And I don't think that's a bad thing. I mean, the point of the argument is for justices to get their questions answered. They've read the briefs, and also the form of a Supreme Court argument is deceptive, because in form you have the justices seeming to elicit information and reaction from advocates, but in fact they're talking to one another. This is the first time they've discussed the case, and particularly for junior justices who, when it goes to conference, they speak and vote last. They may not have a chance to get their arguments out except at the oral argument. So Chief Justice Roberts, who was a fantastic oral advocate before he went on the bench, he was the Paul Clement of his day, said that the role of the advocate is to kind of be a basketball backboard, and the justices are bouncing questions off of you, and you try to get in the game a little bit, but really it's about the questioning. Another thing about the questioning, and Roberts himself, when he was on the D.C. Circuit, he did a little empirical work of his own for the Supreme Court Historical Society, and he discovered that the key to winning a Supreme Court argument is to have the justices ask more questions of your adversary, because questions are almost always hostile, and the more questions you get, the worse situation you're in.
So the question is, how much do the judges come with preconceived ideas about what they, not only what they think, but what they are expecting to do in the case when they approach the briefs and the oral argument, and is that changing or intensifying at all?
The more culturally and politically salient the cases, the more I think they know what they want to do from the moment they grant cert. In a more minor statutory case where they took it because there's a conflict in the circuits, and they may not have a settled view about what the right answer is, they will come to it fresh, and they will often end up unanimous, and quite likely the initial impulse might have been in one direction or the other, but they will think that consensus is good, that some issues just need to be settled. They don't need to be settled right, because litigants and other people will conform their conduct to what the court says and kind of bargain around it, and you just need a rule. So it really depends on the kind of case. But if they take a case, they took a case the other day on yet another religious objection and gay rights conflict case. You know how that's going to come out. So it depends on the genre of the case.
Are we sure it's a good idea to live stream oral argument, or is the court going to move toward being like Congress?
I think we have enough information now that it has done no harm. If camera coverage, video coverage of the court might pose different questions, but I don't think it's changed. I don't think oral arguments has caused the court to grandstand or even, I mean, there was some concern in that camera coverage would cause the justices to not say things that they might be inclined to say, not pose like wild Breyer hypotheticals, because it would show up on late night TV or something. But the audio has worked out fine, I think.
So my own view on that is the audio has worked out fine, but where Adam said it might change with cameras, I would say it absolutely would change, and this would be horrible and Armageddon, and avoid it. And just from personal experience, the last time I testified before the Senate Judiciary Committee, there were some senators who were asking questions, and there were other senators for whom there were two props. One was behind the senator, and the other was supposed to be me. And the entire interaction was intended to generate clips that then went on YouTube and were used for fundraising, where I thought the point was to think about legislation. And so I would really hate for the court to take any steps toward that direction.
The court is not interested in going there. I think you can rest easy.
Current justices, yes. So Adam, when he's writing about things like the shadow docket, is writing to very legally informed audiences, but also to the public, which is not going to be aware of the nuances in the law. How do you manage those multiple audiences?
Not well. I have this constant debate with my editor, who wants me always to have 2 or 3 paragraphs of explaining what the emergency docket is different from the merits docket. And that like boilerplate stuff drives me crazy because I want to say something fresh. But she's right. Much of the readership doesn't follow the intricacies of this stuff, and you need to explain it every time. I mean, you really need a kind of self-discipline in doing this job, because I like to think of myself as capable of playing in the big leagues, occasionally driving up with something like an insight that might intrigue legal academics. And for the most part, I should try to suppress that, because that's, I'm writing for a general readership. The Times' readership is more educated than most, but they're not lawyers. They're probably college grads. And you have to serve that audience and not have this kind of somewhat narcissistic idea of, maybe I can impress some law professor somewhere because I noticed something.
A mid-20th century criminal law theorist, Glanville Williams, said, "The only thing that most people know about the law is that ignorance of the law is no excuse." Yes. So the question is, the justices who are most likely to vote with the Trump administration are Justices Alito and Thomas, not the 3 justices appointed by President Trump. How do you explain that?
The first Trump White House basically ceded the appointment process to the Federalist Society. And Don McGahn, the White House counsel, basically said as much. And the justices who are prominent in that world would have been appointed had Jeb Bush won, had Marco Rubio won, had Mitt Romney won. Their standard issue conservative legal movement, people who care about Chevron, and good judges. If Trump gets another appointee, it will look nothing like these 3 justices. It will either be sort of a wild, peacocky Fifth Circuit judge, or more likely just a complete loyalist, an Emile Beauvais, maybe a John Sauer. What was the question I was answering?
Why Justices Alito and Thomas then are voting more predictably for the Trump administration than Gorsuch, Barrett, and Kavanaugh?
Slightly different reasons. I think Justice Thomas has never gotten over his confirmation hearing, and is part of his mission. I'm sure he doesn't think about it in these terms, but he has no patience for Democrats. His worldview is fully formed. Justice Alito really completely and consistently seems to me to follow the Republican Party's interests and platforms. And while he's a very good lawyer, it does look to me like he's advocating for a position rather than trying to follow a coherent legal philosophy.
An additional explanation on Justice Thomas would be the longstanding divide between Thomas and Scalia on favoring executive power or congressional power. So you think about cases like Hamdi and Zivotofsky. Thomas is always all in on the executive, and Scalia was like, wait, remember, there's a Congress. And you can see that kind of split among the conservative justices potentially reemerging with learning resources, the tariffs case, where you again had a more pro-executive and a more pro-Congress position, both within the same general approach of originalism. Okay, I think we have time for one more question. Richard. That question is kind of too perfect to paraphrase. But I'll try. So Adam had said that the oral argument is especially an opportunity for the junior justices to be able to communicate with the more senior justices because they're going to speak last in conference, and the justices haven't had a chance to talk. And the question is, they're all in the same building. If this is a problem, why don't they solve it? What is it about the justices that mean they don't have mechanisms for talking to each other before the oral argument happens?
I think there's a norm of not having a lot of in-group, smaller group conversations. There's a sense that the whole conference ought to know most stuff most of the time. It's honored in the breach, but it would be a big change, I think, for them to like pre-game the argument. Why the when they get together and discuss cases, my understanding is that the bigger the case, the more routine the voting is. That is, they go on the table once, nobody really argues with, they state their position, nobody really argues. And I think Kagan has said this publicly. She said she was surprised that in a statutory case of no particular moment, they actually try to be lawyers and figure it out. And on a big social issue case, they just vote. I think it has I think it may have something to do with that they don't want to get angry with each other. They're in an arranged marriage with no possibility of divorce, and
polyamorous.
Oh, the images that brings to mind.
It's a free press. Well, thank you, Adam. This has been a treat.